A tort, in common law jurisdictions, is a civil wrong that unfairly causes someone else to suffer loss or harm resulting in legal liability for the person who commits the tortious act, called a tortfeasor. Although crimes may be torts, the cause of legal action is not necessarily a crime, as the harm may be due to negligence which does not amount to criminal negligence. The victim of the harm can recover their loss as damages in a lawsuit. In order to prevail, the plaintiff in the lawsuit must show that the actions or lack of action was the legally recognizable cause of the harm. The equivalent of tort in civil law jurisdictions is delict. Legal injuries are not limited to physical injuries and may include emotional, economic, or reputational injuries as well as violations of privacy, property, or constitutional rights. Torts comprise such varied topics as auto accidents, false imprisonment, defamation, product liability, copyright infringement, and environmental pollution. While many torts are the result of negligence, tort law also recognizes intentional torts, where a person has intentionally acted in a way that harms another, and in a few cases, strict liability, which allows recovery without the need to demonstrate negligence. Tort law is different from criminal law in that torts may result from negligent as well as intentional or criminal actions, and tort lawsuits have a lower burden of proof such as preponderative evidence rather than beyond a reasonable doubt. Sometimes a plaintiff may prevail in a tort case even if the person who caused the harm was acquitted in an earlier criminal trial. For example, O.J. Simpson was acquitted in criminal court and later found liable for the tort of wrongful death. History. Roman law contained provisions for torts in the form of delict, which later influenced the civil law jurisdictions in continental Europe. But a distinctive body of law arose in the common law world traced to English tort law. The word tort was first used in a legal context in the 1580s, although different words were used for similar concepts prior to this time. Medieval period torts and crimes at common law originate in the Germanic system of compensatory fines for wrongs, with no clear distinction between crimes and other wrongs. In Anglo-Saxon law, most wrongs required payment in money or in kind to the wronged person or their clan. White was paid to the king or holder of a court for disturbances of public order. Wergild, which was a murder fine based on a victim's worth, was intended to prevent blood feuds. Some wrongs in later codes were botleys, that is, unable to be compensated, and those convicted of a botley's crime were at the king's mercy. Items or creatures which caused death were also destroyed as deodans. Assessing intention was a matter for the court, but Alfred's code did distinguish unintentional injuries from intentional ones, whereas culpability depended on status, age, and gender. After the Norman conquest, fines were paid only to courts or the king, and quickly became a revenue source. A wrong became known as a tort or trespass, and there arose a division between civil pleas and pleas of the crown. The petty assizes were established in 1166 as a remedy for interference with possession of freehold land. The trespass action was an early civil plea in which damages were paid to the victim. If no payment was made, the defendant was imprisoned. The plea arose in local courts for slander, breach of contract, or interference with land, goods, or persons. Although the details of its exact origin are unclear, it became popular in royal courts so that in the 1250s the writ of trespass was created and made decursu. However, it was restricted to interference with land and forcible breaches of the king's peace. It may have arisen either out of the appeal of felony, or assize of novel dissize in, or replevin. Later, after the Statute of Westminster 1285, in the 1360s, the trespass on the case action arose for when the defendant did not direct force. As its scope increased, it became simply action on the case. The English Judicature Act passed 1873 through 1875 abolished the separate actions of trespass and trespass on the case. In 1401, the English case Bewley v. Finglam imposed strict liability for the escape of fire. Additionally, strict liability was imposed for the release of cattle. Negligently handling fire was of particular importance in these societies given capacity for destruction and relatively limited firefighting resources. Liability for common carrier, which arose around 1400, was also emphasized in the medieval period. Unintentional injuries were relatively infrequent in the medieval period. As transportation improved and carriages became popular in the 18th and 19th centuries, however, collisions and carelessness became more prominent in court records. In general, scholars of England such as William Blackstone took a hostile view to litigation, and rules against champatee and maintenance and vexatious litigation existed. The restriction on assignment of a cause of action is a related rule based on public policy. English influence. The right of victims to receive redress was regarded by later English scholars as one of the rights of Englishmen. Blackstone's Commentaries on the Laws of England, which was published in the late 18th century, contained a volume on private wrongs as torts and even used the word tort in a few places. United States influence. United States tort law was influenced by English law and Blackstone's Commentaries on the Laws of England, with several state constitutions specifically providing for redress for torts in addition to reception statutes which adopted English law. However, tort law was viewed as relatively undeveloped by the mid-19th century. The first American treatise on torts was published in the 1860s, but the subject became particularly established when Oliver Wendell Holmes, Jr. wrote on the subject in the 1880s. Holmes' writings have been described as the first serious attempt in the common law world to give torts both a coherent structure and a distinctive, substantive domain. Although Holmes' summary of the history of torts has been critically reviewed, modern development, the law of torts for various jurisdictions has developed independently. In the case of the United States, a survey of trial lawyers pointed to several modern developments, including strict liability for products based on Greenman v. Uber Power Products, the limitation of various immunities, comparative negligence, broader rules for admitting evidence, increased damages for emotional distress, and toxic torts and class action lawsuits. However, there has also been a reaction in terms of tort reform, which in some cases have been struck down as violating state constitutions and federal preemption of state laws. Modern torts are heavily affected by insurance and insurance law, as most cases are settled through claims adjustment rather than by trial, and are defended by insurance lawyers, with the insurance policy, a deep pocket limit, setting a ceiling on the possible payment. Comparative law. In the international comparison of modern tort law, common law jurisdictions based upon English tort law have foundational differences from civil law jurisdiction, which may be based on the Roman concept of delict. Even among common law countries, however, significant differences exist. For example, in England legal fees of the winner are paid by the loser. Common law systems include United States tort law, Australian tort law, Canadian tort law, Irish tort law, and Scots law of delict. The Jewish law of rabbinic damages is another example. Although tort in Israeli law is technically similar to English law as it was enacted by British Mandate of Palestine authorities in 1944 and took effect in 1947, there is more apparent split between the Commonwealth countries and the United States. Although Canada may be more influenced by the United States due to its proximity, the United States has been perceived as particularly prone to filing tort lawsuits even relative to other common law countries, although this perception has been criticized and debated. As of 1987, class actions were relatively uncommon outside of the United States. As of 1987, English law was less generous to the plaintiff in the following ways. Contingent fee arrangements were restricted. English judges tried more decisions and set damages rather than juries. Wrongful death lawsuits were relatively restricted. Punitive damages were relatively unavailable. The collateral source rule was restricted, and strict liability, such as for product liability, was relatively unavailable. England's welfare state, such as free healthcare through National Health Service, may limit lawsuits. On the other hand, as of 1987, England had no workers' compensation system, and lawsuits due to workplace injuries were relatively common and facilitated by trade unions. Whereas in the United States, the system of workers' compensation insurance prohibits lawsuits against the employer, although lawsuits against third parties such as manufacturers does occur. The United States also has faced a rise in no-fault insurance for automobile liability in several states. In England, ombudsmen may also take cases which could alternatively become tort lawsuits. When comparing Australia and the United States, Australia's tort law is similarly state law. However, there is a federal common law for torts unlike the United States. The influence of the United States on Australia has been limited. The United States may have influenced Australia's development of strict liability for products indirectly through legislation affected by European Union, and in the 1990s class actions were introduced in Australia. Australia has universal healthcare and welfare state systems which also limit lawsuits. In New Zealand, a no-fault accident compensation system has limited the development of personal injury torts. Conflict of laws. In certain instances, different jurisdictions' law may apply to a tort, in which case rules have developed for which law to apply. This occurs particularly in the United States, where each of the 50 states may have different state laws, but also may occur in other countries with a federal system of states, or internationally.